Welcome back to Land Matters, the podcast of the Lincoln Institute of Land Policy. I'm your host, Anthony Flynn. Well, this month, the nation marks Juneteenth, a now national holiday observed on June 19th, commemorating the day the last enslaved people were freed in the United States in 1865, 2.5 years after President Abraham Lincoln ordered their independence with the Emancipation Proclamation, and 2 months after the Confederate Army surrendered in the American Civil War. Here at the Lincoln Institute, we thought it was an appropriate time to look at how land and property has been threaded through the African American experience and how issues of race and equity continue to be stubborn challenges to this day, going at least as far back in the 20th century to redlining and discriminatory housing practices and exclusionary zoning as well, all of which has cut off the opportunity to build and hold wealth through housing and land for so many over the decades. According to the American Bar Association, Black Americans owned around 14 million acres of land by 1910, which some historians consider the peak of land ownership in the United States. By 2022, Black Americans only owned 1 million acres of farmland and other land in shared ownership, and that represents a 90% decline in Black-owned land, which has had a cumulative value loss of a staggering $326 billion. There's now a concerted effort to reclaim land improperly seized, such as Bruce's Beach in California, which we'll talk about in a bit, and many other examples throughout the South primarily. Our guest today is Mavis Gragg, a self-described death and dirt attorney and conservation professional with nearly 2 decades of experience in real estate, conflict resolution, estate planning, and probate. She's regarded as a subject expert on problem solving and strategy building on heirs to property owners. To that end, she's supported numerous families and service providers tackling challenging issues in innovative ways. Her publications include a book chapter titled Practically Speaking, Strategies to Prevent and Resolve Heirs Property Legal Issues. And that's for inclusion in an upcoming ABA book on heirs property, co-edited by Thomas Mitchell. She's also done extensive research and presented before a variety of audiences, from MIT to the National Press Foundation, and this summer she just concluded a year as a Loeb Fellow at the Harvard University Graduate School of Design. Mavis Gragg, thank you for joining the conversation here at Land Matters.
Thank you for having me. It's great to be here.
First and foremost, how was your year in Cambridge? The Loeb Fellowship is a mid-career program for professionals in the built and natural environment. Have you had a chance to catch your breath?
I'm in Vermont, where it's much more slower pace at the moment, and catching my breath and ready for the next big transition. So definitely has been an incredible year. I think for me, the biggest takeaway was affirmation of the work that I'm doing, because I am doing very specific work with a very specific set of real estate owners in our country, families. And we don't often think about family-owned real estate in the context of the built environment or the natural environment. But as I've shared with folks at the Graduate School of Design and the broader Harvard network, family real estate is generational affordable housing. Family real estate is climate resiliency. Family real estate supports a lot of industries, including traditional agriculture and forestry. So it was wonderful to have that recognition. And then it was just great to take a break, Anthony. I highly recommend having a break in your career where you have the opportunity to reflect on what you've done and build the next chapter. And for me, that next chapter is going full time with my company, Heirs, which has been an adventure. I'm a lawyer. I am not a techie, so to speak, but I am a techpreneur, and it's all in the pursuit of access to justice, which I'm glad I get to share with you about today.
Tell us more about Heirs and what kinds of cases you take on and the problems you endeavor to solve.
With respect to heirs property simply is real estate that is maintained through inheritance. And many families who maintain real estate across generations maintain the ownership succession simply by virtue of people dying, meaning that whereas if I were to transfer my condo to you, Anthony, I would sign a deed and then it would have you as a new owner and we would record it. With families, the ownership is transferring through inheritance, which means that it's not creating a paper trail. It's also creating multiple owners that we don't know of until the actual death event occurs. So then you have over generations of ownership, not only an increase of numbers in owners, but also an increase in complexity of that ownership model. And in my law practice, I found that families were coming to me wanting to stabilize their ownership. Either they had experienced some issue with the third party or they weren't able to get financing. And before we could focus on strategic legal services for succession planning or addressing this issue, we would first have to clear title on their property. And so those of us in the real estate industry know that clear title means that the ownership and encumbrances on the property have been examined and confirmed from an attorney. Well, with heirs property, most families who have heirs property don't have a legal determination of their ownership. So being able to prove your ownership is a problem. Being able to use your ownership to get access to traditional loans or other financial products, to get access to services, to even participate in programs like disaster relief or farming programs can be very difficult because they can't prove it. So all that to say that I found myself frustrated as a solo practitioner that my ability to have an impact on this particular issue for families in North Carolina was limited by my own capacity to do this complex legal process. And I was curious about what role technology could play. AirShares was created to build tech-driven tools to support the legal processes that attorneys like me do with working with heirs property owners, but also to support heirs property owners and other professionals in the co-management and optimization of the real estate. So it's very exciting, very different. Didn't expect to not practice law and solely focus on building tech tools. But what's wonderful is that I'm able to take my subject matter expertise as a lawyer who focuses on inherited real estate and create technology that we hope will have a systemic change on how attorneys work with heirs property owners.
You're saying that as if there weren't enough original problems with land and property ownership, that at the moment of succession or inheritance, for communities of color, that has been a moment of vulnerability where the process breaks down?
I think the disproportionate impact has to do with the intersections with other issues. So, as you mentioned earlier about redlining, for example, we know that communities of color were often excluded from healthy financing tools because of their race. Well, if you add that on top of having a complex form of ownership and vulnerability to predatory behavior, then the impact, I believe, is disproportionate. But if we think about the history of real estate ownership in the US, which maybe I'm skipping ahead, owning real estate has been an act of defiance for most Americans, even though real estate ownership is part of the American dream. Most people in America couldn't own real estate legally until after slavery ended. And then once slavery ended and some of our core laws began to change, we saw that people of color, women, et cetera, could own real estate more easily. However, keeping the ownership then became a challenge. As you mentioned, the Black community accumulated a very significant amount of real estate in a very short period of time. You know, slavery ended in the late 1800s or mid 1800s, but then by 1920, we had peaked in ownership. And that's because we were still facing other systemic issues related to race and have had to fight really hard to keep it. But the same is also true for families who are land rich, cash poor, like families in the area where I grew up in Western North Carolina. I'm from the Appalachian Mountains, which is mostly white families, but many of them are land rich, cash poor, like my family. And many of them struggle with the same issues. It's just when you have intersections of other impact, then the impact is even more disproportionate.
Let's go back a bit, if you don't mind, go way back. Talk about the history of Black land and property ownership after the Civil War, beginning with Abraham Lincoln's policy of awarding 40 acres and a mule, which of course was later rescinded by his successor, Andrew Johnson. It's just incredible to think about how that reparation really was in place and then it was taken away. What were the impacts of that moment in history in terms of land and property ownership?
I think that, especially if we think about the core values of our country, and our country is a pretty young country, but core to being an American is freedom. And the freedom to own property is part of that. So at the same time, you had people actually becoming free, not being considered as property anymore, actually being legally defined as humans. Another aspect of that for formerly enslaved people was the ability to achieve the American dream, to be able to have their own real estate, to be able to grow their families, grow their own food, engage in commerce, what have you. And so the fact that there were some efforts to make that possible, as you mentioned, they were quickly taken away. And so again, it was a very adverse situation for most Black Americans in those early days of being able to own real estate. And then that continues today, although we see it in different ways, which I'm happy to talk about.
I'm still struggling to understand what happened just after the turn of the 20th century. It seems like in the 1910s and 1920s, you had numerous cases where eminent domain seizures and other processes seemed to target Black ownership. What happened there?
Everything that occurred with the ending of slavery and after slavery wasn't just about race and oppressing people of color. It was also a lot about money and growing wealth, but not for most people. It was mostly for white people. And so to that extent, even if there were programs that were offerings from the federal government to Black people, it wasn't altruistic. It wasn't about them being human, but it was part of a bigger effort to bring together our state as a whole. So I guess in a sense, there was a different kind of struggle between the North and South following the Civil War that pervaded. And what we saw in the South, which is where you had the highest concentrations of African Americans living by virtue of slavery, and where you had the highest concentration of African American real estate ownership, there was a very violent system in our southern states in which families were actually losing their lives or threatened to lose their lives because of their owning real estate. We saw courthouses being burned down. We saw records being stolen or destroyed. We saw government actors in the local governments even playing a role in interfering with these families' rights to own real estate. So we're talking about a very, very violent era in US history and within our legal system. Alongside that, as it relates strictly to real estate ownership and the different bundles of rights related to real estate ownership, I think that our state have failed families by not including a bundle of rights, of legal rights that are responsive to how families operate. And by that, I mean that with heirs property, with inherited property, the bundle of rights you have is called tenants in common. And tenants in common is the same bundle of rights that you and I, Anthony, as unrelated people would have. It provides for an undivided interest in the property. It requires or it allows any owner to transfer their share while they're alive. And when they die, their ownership share goes to their heirs, not their co-owners. What if the states had a different bundle of rights specific to generational family ownership that ensured that families could make decisions easily without requiring unanimous agreement, that could ensure that the ownership is impervious to predatory behavior from outsiders? That's something that was also happening alongside all of the other things I just mentioned in our system. Our laws have never changed around how families own generational real estate ever. So now what we see present tense is that partition actions, for example, have been leveraged to usurp family-owned real estate, meaning that third parties have specifically targeted heirs property, often in communities of color, buy a single interest and then use the right as a co-owner to force the partition sale of the property. We've now seen more attention to this happening and more efforts to change laws, including the Uniform Partition of Heirs Property Act, which Thomas Mitchell, who you mentioned earlier, was one of the lead drafters of. So we're now trying to find workarounds, but I would love to see some of our core real estate laws change to enhance that ownership model for families.
I wonder if we can look at the case of Bruce's Beach now in Manhattan Beach in California, and whether you think that was a pivotal moment in all of this. It was one of the few successful efforts recently to see this return of land that had been taken from the family. Is it a harbinger of things to come?
I think so. What we saw out of the Bruce's Beach case is more initiatives that are either raising visibility of the issues with real estate ownership in America, particularly amongst people of color or people who are land rich, cash poor. I think it also highlighted very easily and very visibly how various actors, both in the private and public sector, do bad things. in the Bruce's Beach case, they even found documents from the local government in which actors were basically describing their own racist acts. They literally were seeking to end this couple's ability to own that property, and it wasn't because of a public good. And it's in writing. So I think that that case was wonderful in terms of bringing that kind of visibility and seeing that, yes, governments do that. That was a while ago, but we still see that stuff happening today, unfortunately, where local government actors, whether they're in the court system or the tax office, et cetera, are still doing things that are pretty bad. The Bruce's Beach matter is also an interesting thing to look at in understanding wealth in America, because the Bruces, they acquired that property around the same time that the Hiltons began, the Hilton hotels, their empire. So I'm using Hilton as a comparison, considering that the Bruces were in the hospitality industry with their land. They were using it to support recreation and gathering and so forth in Manhattan Beach. Well, what if the Bruces had been successful in retaining ownership of their property and their empire, so to speak, bloomed from the early 1900s to the present day? Could you imagine? Like, it's hard for me, even as a optimist, it's hard for me to imagine a Black equivalent to the Hilton empire, but it could have been. And so when we talk about the racial wealth gap, if people say, just do good, lift yourself up, work hard, follow the rules, it will happen. The Bruce's Beach case is a very clear example of how that's not true in America, unfortunately. And we still have a long ways to go. So I'm really glad that the family was able to see some positive resolution to that. And I'm also glad that the actors that played a role in even opening up this case again step forward, because it does appear to me, just from my own personal observation, that it was individuals within LA County and the state decided to question whether they can make something better than what it was. And that kind of kicked things off. I'm also glad that the legal counsel for the family put forth this effort, because it was not an easy effort. So yeah, I think it's a great example of collective action as well.
Now, if you have a typical case you might share with us, perhaps one that's been resolved, you don't have to name names, but what would be a typical case that you're doing now?
Yeah, so most of the families that I work with in North Carolina are agricultural landowners, meaning they live in rural areas. They have some acreage. Historically, they've used their property for farming. Presently, they may be doing farming mostly as a hobby, but also they have trees. And so they have the ability to participate in conservation and sustainable forestry. All of the families that I work with are land rich, cash poor. But to bring a couple of examples to mind, I would say on a positive side, there was a family that had substantial acreage, and they lost quite a bit of it over time due to some of the circumstances that I described before. But more recently, they have been participating with a local family-owned forestry program and learning about their property and reconnecting to it in a very unique way, and realize, okay, we still have 35 acres. We used to have 100. We're down to 35. But how do we keep this in the family for good, for the future? And so, buoyed by their educational experiences with this local organization, they then sought my services to, one, understand what's the state of things from a legal perspective, and then what's required to resolve it. And so we were able to complete the title search and then put it into a succession plan. And now they feel good. They've brought their younger generations along. They have a garden, they have a farm, they have a forest management plan. It's awesome. A similar example in terms of the location and it being ag land and a Black family, we were never able to resolve their matter. So same thing, they had had the property for a long time, since the early 1900s, and it had been passed down through inheritance. They had an incredible amount of owners, and they didn't have capital to pay for legal services. In fact, the client went MIA for a year. I didn't hear from him for a year. And when I finally caught up with him, he said he had to choose between paying property taxes and paying me, which of course doesn't feel good, because I understand that he's trying to stabilize ownership and keep it in the family, but he's fighting it from multiple angles, trying to keep the taxes up, but also trying to resolve these legal issues. And then more recently, I've seen some examples. I don't take on client matters anymore, but I do assist attorneys who are working on heirs property matters. And so we've been working with the family. One of the attorneys I work with has been working with the family that has close to 60 acres of land, beautiful property. They've experienced tremendous injustices. But what's wonderful about their property is that within those acres, they have, I would say, 6 households. So they have 6 dwellings on their property that are serving their whole extended family. Like that is economic cooperation, if anything else. That's so resourceful. This is a very land-rich, cash-poor family, and they've been able to survive, notwithstanding legal issues, because they've been able to work cooperatively on the property and optimize that asset.
Well, you've got working landscapes and agriculture, but in this time of being concerned about climate change, some of this land has incredible value now, whether it's for conservation easements or carbon offsets. Do any of those kinds of things represent some new wealth building opportunities?
That's absolutely true. The highest proportion of forest ownership in the U.S. is families. And it's good that we have organizations like the American Forest Foundation, where I used to work, where they're focused on family forest owners. So yeah, the opportunities for climate action should necessarily include family-owned real estate. As an example, World Wildlife Fund and Kimberly-Clark, who sources heavily from the wood basket, which is the southeastern United States, they did a study around conservation and forestry in the Alabama, Mississippi. And included in that study was looking at what risk exists with heirs property. And what they saw was that there's a lot of heirs property in those 2 states. So there's a lot of property that's owned without clear title, that's owned by lots of people, et cetera. And while loss of ownership through predatory action is not necessarily the biggest threat is that these families are often physically dividing the property into smaller parcels. And when it comes to conservation practices and to harvesting timber, the smaller the acreage, the harder it is to service those properties. And so these 2 organizations that are not legal organizations, one is a paper products company, one's a conservation organization, they understood that they too had to play a role in supporting heirs property owners having access to legal services, and did support that by creating a fund and setting up an initiative in those 2 states. They saw the value of family-owned property to conservation and timber. And we see more and more of that. I mentioned legislation, the Uniform Partition of Heirs Property Act. That's model legislation in which if a state has adopted that legislation, any partition action involving heirs property will have an additional layer of due process rights for the owners. Well, that legislation is one of the most adopted model legislations in our country's history. It's been adopted in 23 states. And that's largely been galvanized by the conservation and forestry communities, meaning that the coalitions seeking passage in Florida, Texas, Montana, New York, largely have been green organizations, which is pretty phenomenal, I think. In fact, in my home state of North Carolina, when I had my law practice, I was approached by Audubon, North Carolina. What does Audubon care about? Birds. But they saw how heirs property was impacting birds because properties were being lost to developers and then developed and destroying habitats. So it's pretty fascinating to see how issues around family real estate ownership intersect with risk and opportunities around climate resiliency. And it makes my work easier, if I may. If you have a really complex legal issue without any kind of opportunity or optimism, then it's harder to address it. And so it's been wonderful to work with organizations like WWF or American Forest Foundation, even Enviva. I don't know if you're familiar with Enviva. They're a wood products company and they have an heirs property fund. It's been pretty wonderful to have this large group of people really and organizations interested in this issue.
Well, you've ended on an optimistic note, and though we could talk about so much more, that's a good place to conclude. Mavis Gragg, thank you for this time on Land Matters.
Thank you.
For more on the racial dimension of land policy and the increasing attention to equity and racial justice in land use, zoning, and housing, visit our website, lincolninst.edu. Also on social media, the handle is @landpolicy. Finally, don't forget to rate, share, and subscribe to the Land Matters podcast. We'll be back with much more about land policy very soon, but for now, I'm Anthony Flint, signing off until next time.